So, Mr. Nadler, you're on. Mr. Nadler?
Thank you. Thank you, Mr. Chairman. Ms. Eiffel, in your testimony, you cite historical parallels between the urgency of this moment and the end of the Reconstruction era. Could you further elaborate on this point and explain how the Voting Rights Act has until now served as a bulwark against the democratic backsliding we are witnessing in states like Georgia and Texas?
Chairman Nadler, yes. As a matter of fact, I think this is a really important point, because one of the things it's critical to understand about the voter suppression laws that we're seeing is that the rise in these laws began immediately after the Supreme Court's decision in the Shelby County versus Holder case in 2013. Within months, Texas had decided to resuscitate a voter ID law that they would not have been able to pre-clear, that they had in fact tried to pre-clear earlier and were prevented from doing so. We sued and challenged that law, and we were ultimately successful. The trial court, in fact, found that there was intentional discrimination in the creation of that voter ID law. So the progress that Mr. Mobile talked about in Mississippi, for example, was directly the progress that came as a result of the Voting Rights Act, pre-clearance provisions, of Section 2 of the other provisions that protected against conspiracies to interfere with the right to vote. In the Reconstruction period, the Reconstruction Congress was very clear about what would be needed to ensure that Black people would be full citizens. The 13th, 14th, and 15th Amendments obviously are the amendments that were designed to ensure that. The 13th ending slavery, the 14th providing for birthright citizenship for both free and formerly enslaved Black people. Their citizenship had been taken away by the Dred Scott decision, and including several provisions within the 14th Amendment that would punish Southern states that did not allow at that time Black men to vote. And then the 15th Amendment protecting against racial discrimination in voting. In both the 14th and the 15th Amendment, the Reconstruction Congress included enforcement clauses. And those clauses gave Congress the power to enforce the guarantees that were articulated in the two amendments. That is the power from which Congress was able to pass the Voting Rights Act. It's a statute that implements the power that was given to the Congress in the Constitution in the 14th and 15th Amendments. And it was that power that Congress did not use, frankly, for the first half of the 20th century and the last 20, 30 years of the 19th century. They failed to use that power, which is why Black voters were disenfranchised in this country, particularly in the South, for most of the 20th century, until the Civil Rights Movement pushed Congress, forced Congress to wake up, forced Congress to do its duty, forced Congress to fulfill its obligations under the 14th and 15th Amendments, by passing the Voting Rights Act, which provided those provisions that resulted in the ability of many Black people to be able to vote. But what was interesting, and I just add one thing about the Voting Rights Act, was that in the act, in the legislative history, what the Congress said is that the Voting Rights Act, particularly Section 5, was meant not only to address voting discrimination that they were seeing at the moment, but to address what they described as ingenious methods that might be used in the future. They didn't have laws then that kept you from providing water to people online to vote, but they knew that there would be ingenious methods in the future. That was the purpose of preclearance, and that's why we need it back.
I have one question. Mr. Sands, what is the difference between racial and partisan gerrymandering? And what are the challenges of proving race discrimination in gerrymandering under Section 2?
Thank you, Congressmember. The fact is that Section 2 litigation is extremely difficult, and that is because it is litigated under the totality of the circumstances test established in the legislation. That means that you have to put together an array of experts on issues relating to discrimination in voting and beyond. You have to put together lay witnesses who have experienced the kind of vote dilution or vote suppression that you're challenging. It is simply extremely difficult to prove. The same is true of racial gerrymandering, where you have to demonstrate that the predominant consideration by the redistricting body was race, when we know that race is a relevant consideration. The Supreme Court has recognized that. So you are trying to put what is done into a very narrow scope of over considering race. Bottom line, as you know, is that litigation under Section 2 and under the Constitution is extremely expensive, and why we need preclearance as an ADR mechanism to more efficiently address voting rights violations.
Thank you very much, Mr. Chairman. I yield back.
Thank you. And now I'd like to